So that really sort of deals with all the substantive visa types that allow you to work. So what about family members? Well, as we heard earlier, if you have a dependent visa, then you are lawfully employable, as is, no further questions asked. You can join in a business, start a business, study, you can paint pictures of the harbour. It doesn't matter what you're doing as long as it's lawful. In order to get a dependent visa, however, you have to fit within a particular rubric, and that is, you need to be heterosexual, married to your partner, and your partner needs to be a Hong Kong resident, and the resident needs to be able to show that they can put a roof over your head and food on your table. And if you can demonstrate that, then the Immigration Department will, and the relationship is genuine, they'll give the spouse applicant a dependent visa. And the dependent visa that they get, as I say, is actually a better immigration status, all things considered. That's availed to, say, someone who is sponsoring that's only got an employment visa, who's got a business investment visa. Because if you're holding an employment visa or a business investment visa, effectively all you're allowed to do is to work for that particular business of your own or that particular employer. But there's a dependent visa, you can go off and do whatever you want. Children who are children of the union who are under the age of 18 or otherwise in full-time education and are married can go on to get dependent visas as well. However, if you are same-sex partners, even if you're married or you have a civil union in another jurisdiction, today you cannot get a dependent visa. The Immigration Department don't wish to separate these non-traditional families, so what they do is they offer a consolation prize of a prolonged visitor visa. Now, a prolonged visitor visa is exactly the same immigration status that you get when you come as a visitor and arrive at the airport and they admit you and stamp you in and what have you. Albeit, in order to get the prolonged visitor visa, which is an out-of-policy application because it doesn't officially exist, they put the applicant through the normal dependent visa provability test, which is roof overhead, food on table, lawful ability to sponsor because of immigration status in Hong Kong. And as long as you can show a prior history of cohabitation that predates your time in Hong Kong, in order not to separate those non-traditional families, they will grant the trailing spouse a prolonged visitor visa. But the prolonged visitor visa is what I've called the slippers and pipe visa, because in essence the only thing that you can do under the prolonged visitor visa is wait for your partner to come home every night and hand him his slippers and his pipe, because you can't do anything else. You can't get a Hong Kong identity card because they only grant for these visas for a maximum of 180 days at a time, so you've got to renew every 6 months, and because you're not a resident, therefore you don't get a Hong Kong ID card. But it's a practical way to keep non-traditional families together, but it's not a particularly suitable way to solve that problem, I think. But that's what they do. And the same situation prevails where you may be in a heterosexual relationship, but you're not legally married, but you're free to marry but choose not to. The solution to your inability to get a dependent visa is a prolonged visa visa. It's the same visa that's granted to same-sex partners in those circumstances. Hi.
If you're on a dependent visa, does it need to be renewed, or does it continue forever as long as you're married to that person?
It has to be, when your current limit of stay expires, it has to be renewed, and as long as you're still in the relationship with your spouse, and then the Immigration Department extend those, not automatically because you have to apply, but there's no questions asked to merit for the extension. They just grant it without too many questions asked.
So when they grant you the dependent visa for the first time, how long does that? 2 years?
No, normally, well, it depends how you come into it. So if you're coming on a dependent visa, riding on the back of an employment visa application, so when the employment visa is approved, normally it's approved for 2 years, and then the dependent visa is approved for 2 years along with it. If the applications are made separately, then normally the Immigration Department will grant the dependent visa to the life of the sponsor's employment visa normally. But then there are other issues that kick in terms of how much validity you've got left on your passport and just other things that can shorten that time frame. But it's essentially, the rule is that whatever your spouse limit of stay is, as a dependent you get that as well. Unless you're a permanent resident, when it's a 2, 3 year extension pattern.
Thank you.
Yeah. Great. Okay, so that's families. And what happens when you get your visa approved, Chris?
What happens? Well, you're obviously very, very happy. I alluded to some of these before. There's often there's often no requirement or no legal requirement to have particular workplace policies for your employees. But as I said before, if anyone's worked in a larger organisation, these sorts of things tend to exist. And not only do they exist, they're enforced in the sense that when you turn up for your training on day one, you're given a copy of the policy to follow. Certain of them obviously make common sense, anti-harassment, anti-discrimination. Social media is an interesting one because we all live in a kind of social media and bring your own device are two kind of modern workplace policies, or certainly modern in the sense of the last 10 years. Social media, you may want to have a policy about who uses Facebook in work, but that or if you can or if you can't, but maybe that's not the issue. The issue is about the ability to post on social media. So, for example, you as the boss, you may want to have the final call on that, or you may have a marketing director or somebody. To begin with, it might just be, fill your boots, post stuff. Let's increase our SEO. Let's post things on LinkedIn, whatever. But you may actually want to have a policy that doesn't allow everybody in the business, and as you get bigger this gets more important, all 50, 100 people in the business to be able to write things about the business on Facebook, LinkedIn, wherever. So that's a useful policy just in terms of control of your marketing enterprise. Disciplinary procedure is worth having almost for obvious reasons. Your employees will be happier, and you will be happier if you're in a situation where everybody knows the kind of the rules of the game. It's not. There's a big difference between, for example, Hong Kong employment law and UK employment law. Obviously, where I'm from, in the sense that in the UK you have you have far more concepts of wrongful dismissal, of not complying with the law and getting rid of someone. Here it's much easier. There's far more protection for the employer than there is for the employee. But nevertheless, disciplinary procedure that would put in place, for example, what happens if you want to warn one of your employees, or you want to review them, or to ask them to improve. What happens if that employee actually disagrees with the decision of their manager? These sorts of things, put in place a structure so that everybody understands what happens almost on the road to dismissing somebody. Not always, of course. Often, a written warning or a review leads to a vast improvement. And termination documents, a written warning and a letter of resignation or a letter of termination are the sort of thing that you need. Going back to what I said before about having records, keeping records of everything. So in theory, from the day that the person comes in from interview to the day that they leave your business, you should have a record of everything that happens in between then with your employee. Remember that consultants are not employees. I've already mentioned this before. It's not something I'm going to get into in detail now, but a consultant could potentially be classed as an employee if they do the job of an employee, i.e. they're doing the same job every day for like 3 years in a consultancy agreement. They may actually be protected by the employment ordinance. But of course, what a consultant should be is somebody who works for themselves, who comes in to do a specific job for a specific period of time. You don't pay MPF, they're not protected by employment ordinance, and then off they go. But you still need the documents I referred to before, NDA. You still need a consultancy agreement. You need written records in place. An employee, when they get the visa, of course, one thing I should have mentioned is that often an employment contract can be subject to visa approval. Mm-hmm. That's maybe something I should have mentioned right at the start. You can give someone a conditional employment contract. That in it says there's a clause that says this employment contract is subject to you getting valid visa approval, which okay, they couldn't work for you anyway, but it's there because you might have difficulties if, for example, a person is based in another jurisdiction at the and says, no, I want to work for you. You gave me an employment contract. But for all these things, it's a question of from having employees, it's a question of investing a lot of time and money in interviewing somebody, employing them, in training them, these sorts of things. And applying, maybe paying to apply for their visa. But if you don't take the time to put in place policies, their documentation, then that's when you can experience certain problems. So these are almost like as a minimum of what you should really consider putting in place.